Good afternoon and welcome to this FedSoc Forum. I'm Elizabeth Slattery, Director of Practice Groups at the Federalist Society. This morning, the Supreme Court heard oral arguments in Trump v. Cook, a case concerning President Trump's attempt to fire one of the members of the Federal Reserve Board of Governors for cause. Lower courts enjoined her removal from office, concluding that her firing without notice and a hearing likely violated her right to due process. Now the case is before the Supreme Court. As always, our usual disclaimer applies. The Federalist Society does not take positions, and all views expressed in this session belong to our speakers. Towards the end of the webinar, we'll open it up for audience, so please start thinking about your questions for our panel. Questions can be submitted with the Q&A function at the bottom of your screen in Zoom. We are fortunate to have two experts lined up to break down today's oral arguments. In the interest of time, I will keep their introductions very brief. Full bios are available in the Zoom Resources tab or on our website. Today we'll hear from Gene Hamilton, who is the president of America First Legal Foundation, and he previously served in a variety of posts in the federal government, including Deputy White House Counsel. We'll also hear from Tom Saunders, who is a partner at WilmerHale, where he focuses, his practice focuses on appellate and government and public policy litigation. Tom has extensive experience representing clients in patent and copyright cases before the Federal Circuit and the U.S. Supreme Court. So with that, Tom, could you kick things off and give us a little bit of background about today's case?
Sure, wonderful to be here. So Lisa Cook's term on the Federal Reserve would be set to run through 2038. But this past summer in August, the director of the Federal Housing Finance Authority made a criminal referral that alleged that in 2021, before she took office, the Governor Cook had submitted mortgage applications for properties in two different states, representing on each of the applications that she would occupy the property as her principal residence. That letter was released a few days later on social media. President Trump immediately called upon her to resign. 2 days later, told the media that he would fire her if she didn't. And then on August 25th, the president posted a letter on social media saying that he was firing Cook. Two reasons were given. One was the deceitful and potentially criminal conduct in the financial matter. And in the alternative, the president said that the actions on these mortgage applications at least showed gross negligence in financial transactions. So Ms. Cook filed suit 3 days later, and the district court in D.C. granted a preliminary injunction. It had ruled on two different grounds. The first was it said there wasn't cause in this case because the for-cause removal requirement for a federal Reserve governor requires in-office conduct, not pre-office conduct. There was also a procedural ruling that said that Ms. Cook was entitled to notice and hearing before her removal. The D.C. Circuit denied an emergency stay application, so left the preliminary injunction in place. And in terms of the merits, it only addressed one of those grounds. And it said that there was a constitutional due process right to notice and hearing, that because there was a set term for the Fed governors, there was a property interest in the office. And so there was something to protect through due process. The Solicitor General's office then filed an emergency application with the Supreme Court on September 18th, seeking to stay the preliminary injunction. On October 1st, the court deferred consideration of the merits until it could have oral argument in January. So it decided in October to leave Lisa Cook in her position on the Federal Reserve. And so the case that came up for argument this morning has important implications for Fed independence, but it's coming up in a posture where there are a lot of other issues surrounding it. So there are a set of merits issues in terms of, is there a pre-removal right here to notice and hearing? Is there a constitutional version of that argument? There's a statutory version of that argument. There are questions as to what such a hearing or right would look like. There are questions about the meaning of the for cause standard and its relationship to other removal standards and what the common law backdrop was. There are questions about the scope of judicial review, with the United States arguing for very limited review of the president's decision. There's questions about the availability of a preliminary injunction at all in a removal case like this, which leads to fights about, was she actually removed from office and being reinstated, or was the court preventing her from ever being removed? And there are questions about all the other equitable factors that go into deciding what should happen with a case while the proceedings are still pending. So all of this and some of the complexity I think we'll talk about from the argument today hit the court all at once without necessarily a clear path for which of those questions have to be decided, and which it could sort of defer review on for now.
So, Jean, I'd love to bring you in. Based on the argument today, was there an area the justices were most interested in? Were they, mostly looking at did they want to get to the substance and the merits, or were they focused more on the procedural issues with how the case came up through the district court, blocking removal?
Yeah, well, I think based on what I heard, in what I saw, and I think other folks can correct me if I'm wrong, is that each justice, of course, has their own set of questions and their own kind of insight that they're looking to provide when they come to actually vote on the outcome of the case. But there's a lot of questions about procedure that were at issue before the court this morning. And I don't think that's surprising, given kind of the procedural posture of this case. We also have, riding alongside of this, of course, a very similar, although different case that's before the Supreme Court. And that's the Slaughter case that involves the FTC and the termination/removal of Becca Kelly Slaughter from the FTC. And so I think what you have and what we saw this morning, or we heard this morning, I should say, I wasn't there physically, is justices trying to opine or trying to find ways to opine on this particular case that's before them, that's not going to head into a likely outcome that they are looking at in the Slaughter case. I think after Slaughter came out, there's a lot of people reading the tea leaves, saying, oh, well, looks like the government's going to substantially prevail on this. The FTC statute is an unconstitutional intrusion on the president's removal powers. Whereas today, because we're in the posture of a stay, and the government has the burden to prove, and there's these equitable factors that must be considered. I think you saw several of the justices wrestling with each of those equitable factors, maybe not explicitly, addressing each of the four prongs, but asking questions that probed, that kind of led you to see, okay, maybe this person is looking at this particular factor or this particular factor. But it seemed less so on substance. There were some questions that could relate to substance, differences in what for cause removal could mean in the context of this statute as opposed to others. But generally speaking, most of the stuff that I heard, in the things that I think will actually carry the day at the end of the day related to process.
Tom, what's your assessment of where the justices were focusing a lot of their questions?
Yeah, I had a similar take. I mean, I think there was a shared frustration with the procedural posture. One of the interesting things about the case is that Lisa Cook's counsel was largely not focusing on defending the DC Circuit's ruling. So its particular ruling that there's a constitutional due process right to a hearing, and was much more comfortable and eager to talk about statutory arguments and the other variety of arguments. So the result was the justices are being pushed into directions of deciding the case on issues that really weren't well ventilated below, because it was all happening so quickly. It was emergency posture. You had limited rulings from the courts below. And so there's sort of a swing back and forth between testing the merits, probing what they might say on each of these issues, and then seeming to pull back. And justice is sort of across the ideological spectrum, looking for, is there a narrower path here? Can we say less in this context to resolve this issue and then send it to be sorted out below? In terms of sorting out below, too, there was a wide range of different reactions. Um, some of the justices were were really bothered by the lack of a factual record. I mean, they were pointing out that even some of the basic documents and facts aren't in the record. This question of what really happened here, is there, if there's smoke, is there fire? Uncertain, wanting somebody to be able to hash that out. And then there are complicated questions on the for cause standard about how you read the statute against other provisions in other statutes that have different language. How do you read it against the common law backdrop? What does the common law say? Some of the justices seem to have made up their mind on that. Others seemed less certain and looking for ways to say, how can we resolve this without issuing a sort of ruling for the ages on the meaning of for cause?
And on the point of the underdeveloped or underbaked record, I think a few times justices, I think Justice Alito asked about, he wanted to hear more about, the allegations of mortgage fraud, and he was directed to Truth Social posts that are not exactly the same thing as a judicial record. Would you talk a little bit more about how this case and previous removal cases, including the one that Jean mentioned that's currently pending, but there's been several of them in the past decade or so, kind of chipping away at the Humphreys executor precedent. Could you talk a little bit about how the underlying removal issue in this case is similar to those, or how it may be different? For either of you.
I'm happy to jump in. Is that I think it's very different because the key thing here is the Solicitor General's office is not making the constitutional argument. So in all those other cases, you have a sort of Article 2 question, a unitary executive question. Can Congress constitutionally be restricting the president here? In this context, you have the Solicitor General's office, I think, having read the signals from the Supreme Court and concerns about the Fed, not making the constitutional argument, sort of taking it as the starting premise of the argument that there can be a for cause restriction. You would think that that concession would make it easier, but I think the irony is that then opens up all of these follow-on questions about what is for cause, who decides it, what procedures should apply, that in some ways, I think for the majority of the justices may be more difficult questions at the moment than those broader constitutional questions seem to be.
Yeah, I mean, I would just add that because of the procedural nature that this case is in right now, in the posture of a stay, where Slaughter, another case that, again, I think that the writing is on the wall in terms of what the outcome will be in that case. And they granted cert before judgment on that case, where the record is at least more fully developed and kind of elaborated upon. When the court's chipping away at something like Humphrey's executor, it's going to want to make sure that the rulings that I would think, the rulings that it issues, the decisions that it issues, are clear and have good guidelines and parameters. And I think, for example, even with Justice Kavanaugh today, one of the things that you see reading between the lines, at least in his questioning, if you are a person who does so, is a reticence, a kind of reluctance to issue something in this posture that could have significant spillover effects on the economy. without having a fully developed record below the court. That maybe, in fact, from the perspective of the justices, could invite at least some level of questioning, if not criticism, about the decisions that they might make in other cases. I mean, look, in fairness and in full disclosure, my organization submitted an amicus brief in this case, and we laid out our position, and we think that the president's actions here were squarely lawful, and he should prevail. But I can certainly understand how, in this particular posture that this case was brought up in, the court may be more reluctant to render a decision in a stay posture, and instead perhaps make a decision in this case, just say the government hasn't carried its burden in terms of considering all the equitable factors at stake, remand the case down for further consideration. Let the factual record and actual legal records get developed a little bit more. This whole notion that there's some kind of constitutional due process right to a hearing out of the circuit court seems a little odd. And then, of course, issue a decision in slaughter that might actually be more favorable to the government. Again, if you're a person who reads between the lines.
Yeah, now I thought that some of the questioning from Justice Kavanaugh was some of the most interesting, because I think he went beyond just the procedural posture question to expressing some deep concerns. I mean, he asked a sort of question of what is the purpose of Fed independence. He expressed concerns that if there were no sort of meaningful judicial review, that effectively you would transform this into removal at will. He used the expression "what goes around comes around," and asked hypothetical about sort of the next Democratic administration coming in, and I think was worried that if what has happened in this case is the path to removal, that you would have what he described as search and destroy tactics. At the very end of the argument, he pulled this back a little bit and said, there were also concerns on the other side about what do you do with somebody who has an ethics problem and refuses to resign. Concern. So he wasn't sort of pushing the pendulum all in one direction, but I think he has long sort of given expressions about thinking about the Fed being different and having a unique role and trying to find a path to make sure that the sort of insulation from politics that was intended there isn't too easy to circumvent.
And so when Justice Kavanaugh asked about the value or the importance of the Fed's independence, which side was he posing that to, and what was the response, if you recall?
Yeah, he was asking it to General Sauer, the Solicitor General, and I think the response was acknowledging the importance of Fed independence. I think the government's position is we're not interfering with that. They're trying to make it seem like, no, we have a more modest rule. But I think that what you saw was maybe a ships passing in the night on sort of formalism versus pragmatism. Solicitor General Sauer multiple times invoked the presumption of regularity. Paul Clement, who was arguing for Lisa Cook, but in my memory, didn't get any questions about the presumption of regularity, and instead was sort of making hay of the argument that if you don't have a high enough standard for for-cause removal to deter removals, except for in the most egregious cases, we're going to have a lot of these edge cases, and inevitably it's going to draw the courts into questions of pretext. And it seemed to me that Kavanaugh was more in the pragmatist side of, I'm concerned that a formal rule that is too deferential will transform the substance of the standard. The procedures that we have here and the availability of judicial review will inevitably over time mean that what should be a for-cause standard, as the statute requires, will become something else closer to at will, or at least create these incentives to sort of dig up dirt on anybody you don't like in office.
So speaking of application to other government officials, I understand Chairman Jerome Powell was in the courtroom today to hear the arguments. He, is dealing with an ongoing, DOJ investigation. So what implications do you think that this a ruling in this case could have for other members of the Fed? Since I think it seems likely that it will be cabined from other types of officials.
So it's kind of funny because, again, I wasn't in the court this morning. I wish I could have been to see precisely where they were sitting in the courtroom, precisely how close they were to each other. It's been reported that they were not sitting next to each other, which is just interesting for all kinds of reasons. But I think it's just going to depend on what the court does, how quickly it renders a decision in the stay posture. If they come out with something next week that just says, "Hey, look, there's too much for us to be able to make a decision right now based on the facts and the record before us. We're denying the stay, but we're remanding for further development and consideration of the following things," or even if it's just not with any particular direction, where they just issue something that's a little more ambiguous. I think that the implications for other members of the Fed are that look, they're going to be largely protected from their perspective from removal under similar circumstances, and at least until the kind of status quo changes when it comes to executive removal of similarly situated individuals. Now, the counter to that, of course, is that the other members of the board, the Federal Reserve, don't have significant allegations of mortgage fraud being levied against them. And so, look, I guess it just kind of depends. We'll see what happens. We'll see how the court comes out. But if it's a situation where the court is if they provide any kind of how to say this, bright guidelines based on this posture, I would be very, very shocked. And so I don't think that given the posture of this case, that anyone can read too much into necessarily what it means for other folks who might have other considerations at issue, other than significant allegations of mortgage fraud.
Yeah, now I was sitting there the whole time thinking the other way around, which is not what does this case mean for Jerome Powell, but what does Jerome Powell mean for this case? I feel for the Solicitor General's office. I think any practicing lawyer doesn't like big developments that may make your position seem less modest happening this close to argument. I do think that some of, besides the Justice Kavanaugh question I talked about, I was very interested in Justice Barrett's questioning about the stay factors. And this is sort of her first set of questions in the argument. I think that she, in her mind, was questioning how much harm there is to the president and public from leaving this official in place, and seemed to be drawing a distinction between, somebody who might be even more firmly in the executive branch, where there's sort of the argument there that you're interfering with the president's ability to do his job, and sort of pushing back on the harm to the president with respect to not leaving one Fed governor in place for this time. Also tying in the nature of the allegations, the fact that this isn't a a murder allegation. Obviously, the government's position is this is very serious. It's a financial crime for a financial regulator. Um, and then what you heard from Justice Barrett was weighing that against other equitable factors, which in her mind included risks of recession, public panic. Um, and if they're thinking about these removal cases in those terms, in terms of the Fed, then it does provide a lot of insulation for Jerome Powell and others, because you really would have to have some allegation that is vastly moving the needle on the merits in terms of seriousness to get around this sense of I'm balancing the harms, and I see the harms of sort of perceived erosion of Fed independence being much greater than the perhaps more theoretical harms to the president of not being able to immediately remove somebody while the process plays out.
And Justice Barrett, in that line of questioning, also did point out that she's a judge, not an economist. So maybe some of that balancing would be hard for the court to do. Jean, any comment on that line of questioning?
I mean, look, it is interesting because the public interest factor. I mean, if the court's thinking about it in those terms, that's going to be a really difficult, or any justice or number of justices thinking about that in a state posture. It's going to be a really difficult hurdle for the government to overcome. If there's this perceived notion that somehow the erosion of the Fed's independence is going to, cause significant harm to the economy, then I think they're going to have that in the back of their minds all day, every day, because they are people too. Now, I mean, that brings up bigger questions in my mind. Well, what exactly is the Fed? Constitution has, three branches. And this historical legacy of kind of these national banks and their independence and the importance of that and everything else. Those are bigger questions that come to mind. And of course, now they're not present in this particular case because of the posture that we're in. But it does invite broader, bigger picture considerations down the line once things do get further factually developed about hopefully that we'll see kind of play out here, especially in light of clear guidance in the Slaughter case. When that comes out, at least I could see the court deciding that case on fairly broad grounds, but narrowly saying or dropping a footnote saying this ruling has no effect or application to the Federal Reserve Board of Governors, the case still pending or something. I could see them doing something like that when they issue that decision later this spring. But it's quite frankly from a lot of perspectives, how deep you go down this rabbit hole, it gets really, really even more interesting. And the president's ability to remove, or the importance of the president's ability to remove somebody on the Fed Board of Governors grows, I think, the more value that you place on kind of the constitutional system that we have set up versus amorphous, independent, quasi not non-governmental entities, quasi-private entities like the Federal Reserve.
Yeah, I thought it was interesting that there was so little probing of the role of the Federal Reserve. I think the argument largely played out on the Open Markets Committee setting interest rates. There was one exchange where the Solicitor General, in speaking to Justice Thomas about sort of, well, where does this fit in the executive branch, was trying to push the idea of the Fed's mandate has expanded greatly over time to make it into more of a financial regulator. One other area that I thought was interesting, and I think is a big tension in terms of how they move forward, is with this dissatisfaction with the procedural posture, the question becomes, if you punt and send it back for more proceedings, what does that look like? And a number of justices we're talking about this notion of a hearing and latching onto that. Justice Kavanaugh asked sort of like, what's wrong with more procedure? Maybe it leads to different decision making, and maybe this is a way to avoid a bigger decision for now. Justice Kagan pushed a little bit in that direction. At the same time, for the other justices, I think some of their greatest skepticism was directed to the hearing requirement because they just sort of didn't understand what purpose it would serve. And I think particularly as you think of the justices in the middle, the Chief Justice was in there with that skepticism. So even though he had some comments on the facts that may have expressed some sympathy to the idea of maybe this is an inadvertent mistake, that type of narrative, sort of couldn't imagine what would this hearing entail? What is there left for you to say? If Lisa Cook's argument is this was just a mistake in the paperwork, what does a hearing look like? And all sorts of, is this a formal hearing? Is this just people sitting around a conference table? And so this led to what I think is going to rapidly enter the lexicon among nerd Supreme Court lawyers, which is the full Taft. And this was a term that was used by Paul Clement in arguing for Lisa Cook. He pointed out that in a removal case while President Taft was in office, he had decided to do a full-on procedure, brought in neutral decision makers, including the future Justice Felix Frankfurter, and had what looked like a trial-like proceeding. Now, Paul Clement, I think, knew that this wasn't going to be palatable as a minimum requirement in every case. Justice Gorsuch had some great questioning saying, well, wait a minute, this decision of for-cause removal is given to the president by statute. So it's a little weird to sort of require a neutral decision maker in there. And so I think what you saw Paul Clement pushing was a sliding scale, which was he was trying to get them to latch onto the idea of if the president provides the full Taft and has robust procedures, then there may be more limited scope for judicial review. The court can, under Loper-Bright, review the legal questions, the outer boundaries of what's meant by for cause. But factual questions and application of fact to law, in his view, would be a lot more deferential the more procedure there's been. Conversely, if there doesn't seem to have been procedure or factual development or issues considered up front, then there'd be more role for the courts to probe that on the back end of judicial review. Now, he also got pushback on this from Justice Alito. He said he didn't think the sliding scale approach was helpful. He needed to know sort of what was the minimum amount of procedure. But for better or for worse, we heard a lot about the full Taft today.
And hearing by Truth Social, would that be the minimum Alito was looking for? Well, I want to remind our audience that you can submit questions through the Q&A box at the bottom of your screen. Any other kind of surprising lines of questions? Did Justice Jackson have anything interesting to bring up today?
So I think Justice Jackson was probably the closest to Justice Barrett in focusing on the balance of harms, and specifically said, we don't have to decide anything else to decide this interim question. She also, I think, less convincingly, probably out on her own, was focused on the lack of notice. Maybe Justice Sotomayor shared that. Paul Clement, as lawyer for Lisa Cook, really wasn't pushing the notice issue, because also at this point, everybody's clearly had noticed there's been an opportunity to air the arguments. Justice Jackson did have questions, though, about is a social media post enough? Doesn't the president at least have to send the letter to the person who's been removed? And so I think what she was really testing there is, can you have a process that says, I've posted on social media that you're removed, and there being immediate consequences to that without something at least providing notice. But I don't think there was anybody else other than some barbs about social media from Justice Sotomayor. it seemed that anybody else had interest in the notice issue standing on its own as apart from the hearing issue.
So, oh, go ahead, Gene. Did you have something to add?
I mean, I was just gonna completely agree. And honestly, none of the questions or the lack of questions from one justice in particular were that surprising, given kind of where a lot of these justices are with their jurisprudence. And again, considering the procedural posture of this case, I think that's the driving, animating factor that will lead to the court's ultimate outcome in this case. If this case was decided on the merits, I think we'd have a completely different hearing than we did today. There's going to be lots of interesting questions if this case does come back or when it does come back that will have to be grappled with. And this whole notion, I mean, I don't see this whole notion of a pre-removal hearing being something that is latched onto by a majority of justices in the future. But it's a thing that we will get to explore more in the future at more of these webinars. They will come back and they will talk about how prescient Tom's words were here as we debate this particular case.
And we got a little preview. I mean, on the assumption that this all ends up eventually with a ruling on the merits and more guidance on what is for cause, I think there are a few things we can take away. One is Justice Alito absolutely hates the idea that there's some line between pre-office conduct and post-office conduct, and had all of his colorful Nazi Klan sexual misconduct before taking office hypotheticals to deploy there. And then I think where the sort of real movement is, and where I think we could see this case end up in, I don't know, a year or two if this plays out, is this question of negligence, gross negligence. How is that factor with cause? I don't think that if there was intentional criminal mortgage fraud by a financial regulator, that you would struggle to get 5 votes to find that that was cause. I think there was some probing of, well, is this an inadvertent mistake, or is it gross negligence? Is gross negligence going to be enough? What's the difference between gross negligence and mere negligence, which they didn't seem to think would be enough? And so there were some early hints at where the lines might be drawn in a way I think that would give some hope to Lisa Cook, but very much dependent on where the factual allegations go and whether, when that you have sort of a full record and someone has dug into this more, how the explanation that's being provided stacks up. Because the justices definitely felt like they didn't have the facts before them today, didn't have a handle on it.
So we have an audience question asking if someone could explain the hypotheticals about termination due to non-disclosure agreements. Are either of you familiar with that hypothetical?
Yeah, so that was part of probing this pre-office conduct. So the non-disclosure agreement came in because I think it was Justice Alito's way of indicating that this was something that wasn't known. That there was a separate question about what do you do about if there was malfeasance before taking office and everybody knows about it and you get confirmed. Could that be a reason for the president to remove you for cause? Or at that point, does it sort of fall out of the equation because the Senate knew about it and confirmed you anyway? So this was trying to get at the, what if it's unknown? What if it's pre-office misconduct, but it comes to light while you're in office? And what does that mean? And I think, there are attempts to dodge the question a little bit. I think there's a nod towards certain aspects of such conduct could rise to the level where they would truly interfere with your ability to carry out the office, no more clearly than if you were convicted while you're in office, even for pre-office conduct. And so there was I think not a big appetite for a bright line rule that says you can't consider pre-office conduct, but instead an attempt to say when can you consider it? And lots of arguments, Lisa Cook's argument was based on their reading of the common law cases to say there's basically a seriousness of the offense divide there. And so it depends on whether it was, a pre-office misdemeanor or was it a more serious offense.
Yeah, I mean, I think those are all really good points. And quite frankly, there is kind of an intuitive notion of, fairness or justice that says, well, if the Senate knew about all this stuff and they confirmed you anyways, then, can the president later say it is for cause to remove you because of something that everybody knew about in advance? And I think reasonable minds can agree to disagree on that, but I think it's fairly clear that where that ultimately though leads to are questions about, well, who decides? Who decides? The courts or the president, or Congress? And Congress clearly knows how to write statutes. And Congress can provide, and it has provided in other contexts, the bases upon which somebody can be removed from office. Now, look, some of those might be unconstitutional, and that's what we'll see if that plays out in the Slaughter case. But who gets to decide? I just think it's very hard for a court to come in and second guess a president's um, determination that cause exists on any kind of legal theory that has any resemblance to a presumption of regularity, which we were discussing a little bit earlier too. I mean, then you're having to get into the motives of the president, and you're having to second guess, and ultimately, who decides then if the president's cause was sufficient for him? Because look, if the president looks at something like this and says, I'm sorry, but these allegations of fraud are serious and significant, and that undermines confidence in the financial markets. To have somebody with this type of a record on the Federal Reserve Board of Governors, that it would be hard to second guess the president's determination that cause existed if there was something that came out like what happened in this particular case. But the notion that it's only limited to convicted crimes or that it's anything else seems just not like a very good winning argument at the Supreme Court. And quite frankly, I don't know. We'll see what happens. We'll see if we ever get to an actual resolution of it in the context of the Federal Reserve Board of Governors. It tends to be the case in life sometimes that factual developments can prevent hard legal and constitutional questions from being resolved with clarity. It could be the case that some people just decide to leave on their own because they've got other things to do. They don't need this. They want to go make some money and go hang out with the grandkids or do anything of the sort. So we'll see. Hopefully, we get some of this, get some clarity from the court in a number of these cases coming up, so that way that people can at least make decisions. That's what our constitutional republic is about. And that way, when people go to the ballot box and they cast their ballot for the electors who will vote for the candidate of their choice, they know what that brings with it. Policy decisions that flow from a unitary executive or policy decisions that flow from a lot of different places.
And on the presumption of regularity, I mean, I do think that in some of the skepticism we saw from the questions, there is a view, and I mentioned this from Justice Kavanaugh. We also saw it in the Chief Justice's questioning that if there isn't some form of judicial review here, that the substantive standard would be eroded, which to me is not, a presumption of regularity, but instead a sense that if it's unchecked ability of somebody to make this decision with no one looking over their shoulder in any capacity, then they're concerned about the decisions not being made in good faith there. And I don't think they were at pains to say, we're not necessarily talking about this particular case. I think they're trying to say, this isn't just about one president. They're thinking across administrations. But that was an interesting dynamic. I think there was also a pretty sharp reaction to one of the arguments that the United States was making, which is you can't have an action in equity here. You can't have a preliminary injunction. The only thing you can do is have a mandamus proceeding. And then the Solicitor General slipped in that mandamus doesn't apply to the president. And so I think you saw coming back a little bit later in the argument, Justice Kagan jumped in and really wanted that not to be lost and pulled back up this idea of, wait a minute, you're telling us it's mandamus. You're telling us mandamus doesn't apply to the president. And so therefore you're really telling us no review. And I read that as a sort of signal trying to pick up on some of the Chief Justice's concerns and just make sure that didn't slip past anybody.
So final question, Jean floated the possibility that we could get a quick ruling as soon as next week. So I'd love to hear, Tom, what's your prediction? Are we going to get a decision in the coming weeks, or will they hold on to this one till the end of the term before they hightail it out of DC?
I don't think we're gonna. I don't think we're gonna get a quick decision. I do think I don't think it's necessarily going to go to the very end of the term, because I think they're looking for an exit strategy that avoids deciding all of the big picture issues. The reason I was a little bit more skeptical about how quick it would be is for some of the exit ramps, like the saying, "Oh, a hearing is required." There was so much skepticism as to how meaningful that is. It is a little weird. What would the hearing be? That it wasn't clear that you had sort of just a big block majority that says, of course, that's the way out of it. So I think it still raises the specter of fragmentation. I think even with that, you would get a dissent. And so I think all of that is gonna slow it down, and that we're gonna be talking about certainly months, not weeks, for a decision.
Jean, any final thoughts on when a ruling may
I
come?
mean, trying to predict what the Supreme Court will do and when is a business that could make somebody a lot of money if they were successful 100% of the time. And I'm not in that business. That said, look, I mean, I could see a world in which they issue a decision that's relatively quick, depending on the justices, in some kind of per curiam order or something else that just indicates in any form or fashion that just not yet, not right now, and that they bring that out sooner than later. I could also see a situation like Tom is describing, where somebody wants to make some points and it takes a little bit longer to kind of get that written and fully developed, and ready for publication. So we'll see. It will at least, I would like to think, my prediction would be that they would issue whatever they issue before they come out with slaughter later in the term. And then that gives them kind of some leeway to act the way that they want with slaughter. I think it becomes more difficult for them to try to adjudicate and render a decision on slaughter, hold this case out until after that, and then try to issue some kind of a strange, procedural decision, given the posture of this case, in light of what we think might be kind of a broad pronouncement about the contours that they'll be announcing about the unconstitutionality of the FTC removal protections. So,
well, we'll have to wait and see when that ruling comes out, but we've come to the end of our time. So on behalf of the Federalist Society, I want to thank Tom and Jean for sharing their time and expertise with us today. And I want to thank our audience for joining and participating. We also welcome listener feedback, so you can send us emails at fedsocforums@fed-soc.org. Thank you all for joining. We are adjourned.